Hello, welcome to a webinar on the 2016 BIA ICWA Regulations. I am Mark Vizzola. I'm a directing attorney at California Indian Legal Services, and this webinar was made possible by a grant from the California Department of Social Services. So right off the bat, in typical lawyer fashion, I will offer this disclaimer. We are not going to go through every aspect of the regulations. They are quite lengthy. I'm merely going to try to touch some important points and highlight the differences between the new regulations and existing California law. However, the full text of the regulations is available online, including it will be available on CILS's website, www.calindian.org. So let's go back a ways to identifying the problem. Congress passed the Indian Child Welfare Act in 1978 after finding that Indian children were being removed from their homes at a higher rate than non-Indian children, 35%, largely due to cultural bias and ignorance. The Indian Child Welfare Act was passed to establish minimum federal standards for state child custody proceedings involving an Indian child. And the text of that act can be found at 25 United States Code, Section 1901. The Indian Child Welfare Act has attempted to be clarified over the years. The federal government has issued regulations in 1979, 94, and 2016. Guidelines, which are different and non-binding, came out in 1979 and 2015, with further guidelines last year to complement the new regulations. A final rule, listed as 25 Code of Federal Regulations, Chapter 23, implemented the ICWA regulations that went into effect on December 12, 2016. These regulations were meant to address inconsistent applications of the Act, conflicting interpretations, and persistently disproportionate removal rates. So the very thing that the Act was passed to remedy is still a problem. Now, these regulations apply to Indian child welfare proceedings initiated after December 12, 2016. They do not apply or affect child welfare proceedings initiated prior to that date. The regulations also apply to subsequent proceedings in the same matter, including those affecting custody or placement initiated after December 12, 2016. For example, a case may have involved a detention prior to December 12, 2016, but a termination of parental rights hearing after that date would be considered a subsequent hearing. Therefore, the regulations would apply to that subsequent hearing. Let's start off by talking about definitions. Definitions are very important. They tell us what is meant by certain language, words, and phrases in the regulations. And it just so happens the definitions are alphabetical, but the first one is a very important one. Active efforts, something much talked about since the Indian Child Welfare Act was passed in 1978, but not defined anywhere at that time. So the commentary that accompanies the new definition states that states were inconsistent in demonstrating or in how to demonstrate active efforts. Therefore, the BIA found compelling reasons for setting a nationwide definition. As the agency is involved, this requires assisting parents through the steps of a case plan, including accessing services and resources. Active efforts, we know, cannot be passive. Active efforts mean affirmative, active, thorough, and timely efforts. They are intended primarily to maintain or reunite an Indian child with his or her family, and should be provided in a manner consistent with the prevailing social and cultural conditions and way of life of the Indian child's tribe. and they should be conducted in partnership with the Indian child, the Indian child's parents, extended family members, Indian custodians, and the tribe itself. Active efforts are tailored to the facts and circumstances of each case. It's important to remember that. One size does not fit all. Significantly, the new regulations list examples of active efforts. We don't have examples under existing California law, so this is a big help. I haven't listed all 11 examples here, but I did include 3 of them. Active efforts include identifying appropriate services and helping parents overcome barriers, including actively assisting them in obtaining such services, taking steps to keep siblings together whenever possible, and identifying, notifying, and inviting tribal representatives to participate in providing support and services to the Indian child's family and in family team meetings. Child custody proceeding. The commentary makes clear that the Act applies when the court is considering a foster care placement, even if it ultimately decides to return the child to the parents. It addresses status offenses to clarify that the exclusion of placements based on adult criminal acts, and it defines proceedings in which the Indian Child Welfare Act applies. Now, under the regulations, a child custody proceeding means and includes any action other than an emergency proceeding that may culminate in one of the following outcomes: foster care placement, termination of parental rights, pre-adoptive placement, or adoptive placement. An action that may culminate in one of these 4 outcomes is considered a separate child custody proceeding from an action that may culminate in a different one of the outcomes. There may be several child custody proceedings involving any given Indian child, and within each child custody proceeding, there may be several hearings. If a child is in foster care or another out-of-home placement as a result of a status offense, that status offense proceeding is a child custody proceeding. Custody and continued custody. It's important to keep in mind that these definitions can and will affect the rights of those who have had custody or continued custody of an Indian child. These include parents, legal guardians, and Indian custodians. The term custody by itself is included over 100 times in the new regulations. So continued custody means physical custody or legal custody or both under any applicable tribal law, tribal custom, or state law that a parent already has or had at any point in the past. The biological mother of a child has had custody of a child. Now, custody means physical custody or legal custody or both under any applicable tribal law or tribal custom or state law. A party may demonstrate the existence of custody by looking to tribal law or custom or state law. These changes are likely in response to the Supreme Court's decision in Adoptive Couple versus Baby Girl, decided in 2013. Domicile. The new definition of domicile under the regulations aligns with federal common law, and it clarifies that the domicile of a child whose parents are not married becomes the domicile of the custodial parent. The domicile is important in determining jurisdiction, including over a child within a tribe's exclusive jurisdiction. For a parent or an Indian custodian, the place at which a person has been physically present and which that person regards as home is his or her domicile. A person's true, fixed, principal, and permanent home to which that person intends to return and remain indefinitely, even though the person may be currently residing elsewhere. For an Indian child, the domicile of the Indian child's parents or Indian custodian or guardian. In the case of an Indian child whose parents are not married to each other, the domicile of the Indian child's custodial parent. Now, California Welfare and Institutions Code says domicile is with the parent, guardian, or Indian custodian with whom the child makes his primary residence. So, a slight difference. And I always tell people that you cite the law that has the higher standard, and that will come up again in this presentation. Emergency proceeding. The commentary says this definition was created in response to a lack of clarity regarding these types of proceedings. And further along in the regulations, there are separate standards created specifically for emergency proceedings. Yet, California law currently does not define emergency proceeding. The regulations define emergency proceeding as any court action involving the emergency removal or emergency placement of an Indian child. Extended family member. The revised commentary tells us, and by the way, just so you know, revised commentary means that there was already an existing definition of extended family member. However, it's been revised with changes to the commentary itself. It's important to remember that extended family members are not always Native American or tribal members. Can be more expansive and include family members under the law or custom of the child's tribe. So, under the regulations, an extended family member is one defined by the law or custom of the Indian child's tribe, or, if none, a person who has reached the age of 18 and who is the Indian child's grandparent, aunt, uncle, brother, sister, brother-in-law, sister-in-law, niece or nephew, first or second cousin, or step-parent. Indian child. Now this is very important because the Act only applies to Indian children. The revised commentary clarifies and includes the term citizen and citizenship along with member and membership. The term Indian child is used over 200 times in the new regulations, but its important use is in determining whether the Indian Child Welfare Act applies at all. ICWA only applies if there is an Indian child. Now, there are no major changes in the definition, but just as a reminder, it says that an Indian child is any unmarried person under 18 who is either a member or citizen of an Indian tribe or is eligible for membership or citizenship in an Indian tribe and is the biological child of a member or citizens of an Indian tribe. California law uses the original ICWA definition. And as many people probably know, some tribes use the term member, some tribes use the term citizen, although those words don't necessarily mean the same thing. A citizen might be somebody who is formally enrolled in a tribe, but a tribe might consider a person who is not enrolled to be a member. We'll talk about this later, the fact that only tribes can make this determination. Now, the Indian child's tribe, the revised commentary tells us that the definition follows the statutory definition, but refers to a new process in the regulations found at section 23.109 to make a multi-tribe determination. We'll say more about that later. There is a notable change, though, if you look at the bottom of this slide. In the case of an Indian child who is a member of or eligible for membership in more than one tribe, the Indian tribe described in section 23.109. And there we will talk about how courts are going to make a determination of which tribe is the tribe for ICWA purposes when there's more than one option. Indian custodian. This is a very important role. It's also a very important definition. Indian custodian is something that can be shown through tribal law, and Indian custodians often have the same rights as parents. In fact, in the regulations, Indian custodian is used almost every time the word parent is used. Now, the definition states that an Indian custodian is any Indian who has legal custody of an Indian child under applicable tribal law or custom or under applicable state law, or to whom temporary physical care, custody, and control has been transferred by the parent of such child. An Indian may demonstrate that he or she is an Indian custodian by looking to tribal law or tribal custom or state law. Now, this definition is important because, number one, it acknowledges the applicability of tribal law. But also, number two, it highlights the importance of the role of an Indian custodian. I'd also add that several years ago, many years ago in fact, California Indian Legal Services created an Indian custodian designation form. It's a simple one-page document that can be shown as proof of an Indian custodianship, but that document is by no means required to show an Indian custodianship. It's just convenient to leave a paper trail, so to speak. Now, an Indian foster home, this term is actually used in California law, but it's not defined. The regulations define an Indian foster home as one where one or more of the licensed or approved foster parents is an Indian as defined in the Indian Child Welfare Act. Involuntary proceedings. So the determination of whether a proceeding is involuntary means that the active efforts requirement is triggered, and then higher standards of evidence will come into play. A qualified expert witness is required unless he or she is waived. Now, the definition of an involuntary proceeding under the new regulations is a child custody proceeding in which the parent does not consent of his or her free will to the foster care, pre-adoptive, or adoptive placement or termination of parental rights, or in which the parent does consent, but only under the threat of removal of the child by a state court or agency. Parent or parents. It's important to remember, as is noted under the revised commentary, that the definition doesn't include language requiring an unwed father to take reasonable steps to establish or acknowledge paternity, and stating that the Supreme Court and other case law has already established a constitutional status for the rights of unwed fathers, namely that an unwed father who manifests an interest in developing a relationship with his or his child cannot constitutionally be denied parental status based solely on a failure to comply with technical requirements establishing paternity. Fortunately, the definition is a little more straightforward. Parent or parents means any biological parent or parents of an Indian child, or any Indian who has lawfully adopted an Indian child, including adoptions under tribal law or custom. It does not include an unwed biological father where paternity has not been acknowledged or established. Status offenses. The new commentary tells us that that the Indian Child Welfare Act applies to offenses if any part of the proceeding results in the need for an out-of-home placement of the child. Now, California law doesn't have any provision on point, and this goes back to the WB case decided in 2012. But a status offense under the regulations is an offense that would not be considered criminal if committed by an adult. In other words, these are acts that are prohibited solely because of a person's status as a minor, like truancy or incorrigibility. Tribal court, very important. The commentary acknowledges that this includes tribal governing bodies such as a tribal council, under the inclusion of other administrative body of a tribe vested with authority over child custody proceedings. The definition of a tribal court is either a court of Indian offenses, a court established or operated under the code or custom of a tribe, or any other administrative body of a tribe vested with authority over child custody proceedings. This is important because not all tribes have their own court systems. Courts are expensive, and some tribes cannot afford them. Some tribes are too small to justify a standalone court. Some tribes pool their resources with other tribes to form what are called consortium courts. And the importance of a tribal court, as we'll see, comes up when a tribe requests transfer of jurisdiction from state court to its own court or to its own administrative body. So the regulation defines tribal court in such a way that it allows for tribal councils or other administrative bodies to be acting as tribal courts for ICWA purposes. Upon demand. Now this phrase is very important because it helps us determine the application of the Indian Child Welfare Act. If a parent cannot have a child back upon demand, then the proceeding is subject to the involuntary proceeding requirements in these regulations. If the parent can regain custody upon demand, then the placement is not subject to the Indian Child Welfare Act. So, for example, divorce or any voluntary placement chosen by a parent. Now, the words upon demand are used in California law, but there's no definition for it. The definition under the regulations is that the parent or Indian custodian can regain custody simply upon verbal request without any formalities or contingencies. Voluntary proceeding. ICWA does not apply to voluntary placements. Voluntary proceedings have their own separate requirements, and we'll talk about those a little later. So the definition of a voluntary proceeding under the regulations is not an involuntary proceeding, such as a proceeding for foster care or adoptive placement, but a proceeding that the parent has consented to for an Indian child, or a proceeding for voluntary termination of parental rights. So this is important to determine the application of the Act. Now we're done with the definition section. Of course, we'll see those terms come up throughout the rest of this webinar. But next we're going to move on to notice. And this is a short but important segment. There's a change in notice provision. The new regulations at section 23.11a require notice in involuntary proceedings only. This is different from California law, which requires notice in both voluntary and involuntary proceedings when they involve an Indian child. The regulations say that notice must be sent when the identity and location of the child's parent or Indian custodian or tribe is known. If not, then the notice should be sent to the Sacramento Regional Director for the BIA. California law tells us that notice is required to potentially affiliated tribes even if the identity of the child's tribe is not known, but information connects him or her with a particular tribe or tribes. So in this case, California law sets a higher standard for notice. And I'll repeat, I always argue that you go with the higher standard. Now, this slide sets out like a roadmap of where we're going with the rest of this webinar. We're going to talk about general provisions, pretrial requirements, petitions to transfer, and so on. And we will have chapter slides to kind of guide you and let you know where we are in the presentation. But these are all the topics that we hope to get through in our remaining time. So let's start out with general provisions. So Regulation 23.11 23.103 sets out ICWA requirements and when they apply, including at emergency proceedings. California law is silent about whether or how the Act applies at emergency proceedings, so the regulations are more thorough on this point. It's important to note, however, that most of the Indian Child Welfare Act's requirements and opportunities for tribal involvement begin at the disposition phase, and we're not quite there yet. Now, this is a very handy chart, and it is included in the full text of the regulations. So I'm not going to go through it slide by slide or section by section, but it tells you which types of proceedings each section of the regulations apply to. For example, 23.107, how should a state court determine if there is reason to know the child is an Indian child? Well, this section applies to emergency proceedings, involuntary proceedings, and voluntary proceedings. If we go down, however, to the next slide, you'll see section 23.113. What are the standards for emergency proceedings involving an Indian child? This only applies to emergency proceedings and nothing else, and so on and so forth. And we tried to recreate the entire chart as it's printed in the regulations in this presentation because we think it's very helpful. Now, inquiry or notice of a tribe. Regulation 23.105 says that to provide notice or obtain info or verification, notice should be directed as follows. See the list of tribal agents for service found in the Federal Register or on the BIA's website. For tribes without a designated agency or agent, contact the tribe directly and ask. Or if these fail, contact the local or regional BIA office. It's important to note, however, that tribes should be vigilant about checking on their listing for tribal agent in the Federal Register. Sometimes this information is out of date and it makes notice difficult. So tribes want to stay on top of that. I will add that California law does not really address interaction between the agency and tribes beyond the formal ICWA notice sent by registered mail with return receipt requested. Now, pre-trial requirements. So this is like preliminary determinations that a court would have to make. First off, and this is very important, determining if there is reason to know a child is an Indian child. Well, the BIA regulation 23.107 tells us that courts must ask each party to a proceeding whether they know or have reason to know a child is an Indian child. And if there is reason to know, but insufficient evidence, the court must then confirm by report, testimony, or declaration on the record that the agency used due diligence to identify and work with all the tribes which there is reason to know the child may be a member of and verify the child is a member or the biological child of a member and eligible for membership. And, very important, treat the child as an Indian child unless and until it determines on the record the child does not meet the definition of Indian child. Now, California law obligates courts and agencies to make this inquiry. So, if I didn't say it earlier, the Indian Child Welfare Act provided minimum standards for states to follow. But states are free to adopt higher standards, and California has done that. This is one case in which California has adopted a higher standard than that required under the original Indian Child Welfare Act. Now, a court, upon conducting the inquiry that we talked about in the last slide, has reason to know a child involved in an emergency or child custody proceeding is an Indian child if one of the following is true. Any participant in the proceeding, and that could be an officer of the court, the tribe, an Indian organization, or agency, informs the court that the child is an Indian child. Or if any participant in the proceeding informs the court that it has discovered information that the child is an Indian child. If the child, him or herself, gives the court reason to know that he or she is an Indian child. If the court is informed that the domicile or the residence of the child's parent, or the child's Indian custodian is on a reservation or in an Alaska Native village. If the court is informed that the child is or has been a ward of a tribal court, or if the court is informed that either parent or the child possesses an identification card indicating membership in an Indian tribe. Now, determination of ICWA status. This is very, very important. Only the tribe can determine if the child is a member or citizen of the tribe, or eligible to be a member or citizen of the tribe for ICWA purposes. A state may not substitute its own judgment for that of the tribe, but a state may rely on facts or documentation indicating tribal determination of membership or eligibility, such as enrollment documentation. A tribe's determination is conclusive under California law. However, information that the child is not enrolled or is not eligible for enrollment is not determinative unless the tribe confirms it in writing that enrollment is a prerequisite for membership. So remember, enrollment and membership are two different things. That's a very important distinction. What happens now when you have more than one choice as to a tribe? Well, Regulation 23.109 tells us if the child meets the definition of Indian child for more than one tribe, deference should be given to the tribe in which the child is already a member, unless otherwise agreed to by the tribes. If the child is a member of more than one tribe or eligible to be a member in more than one tribe, the court must provide an opportunity in any voluntary proceeding for the tribes to determine who should be designated as the tribe. If they cannot agree, then the state court must choose the tribe with which the child has the most significant contact, and these are the factors: the parent's preference for membership of the child, the length of domicile or residence on or near the reservation of each tribe, the tribal membership of the custodial parent or Indian custodian, the interest asserted by each tribe, whether one of the tribes previously adjudicated the child in tribal court, and the self-identification of the child if he is of sufficient age, and sufficient age is not defined. That probably means that the court would have to take the child's self-identification into account if the child appears mature enough to speak on that point. Under California law, we have what's called a significant contacts test with slightly different factors. Some of them are the same, but some of them are different than what we get under the regulations. So, length of residence on or near the reservation of each tribe and frequency of contact with each tribe, the child's participation in the activities of each tribe, the child's fluency in the language of each tribe, those are different. They are not present under the regulations. Whether there has been a previous adjudication of the child by any of the tribe's courts, residence on or near one of the tribe's reservations by the child's parents, Indian custodian, or extended family members, tribal membership of the custodial parent or Indian custodian, interest asserted by each tribe in response to the ICWA notice, and the self-identification of the child. So a couple of differences, some variation in wording, but a lot of similarity between the regulations and existing California law. Notice requirement. Now, notice under the regulations requires information about direct lineal ancestors such as grandparents. This is less burdensome than California's requirements, which include biological parents, grandparents, and great-grandparents. When the identity of the parents or tribe is unknown, the regulations tell us to notice the BIA regional office. So California law, again, has a higher standard than what we see under the new regulations. It also requires maiden, married, and former names or aliases. Emergency proceedings. Remember, emergency proceedings are defined under the new regulations, but are not defined under California law. So Regulation 23.113 says that petitions for court-authorized emergency removal to include a statement of risk of imminent physical damage or harm to the Indian child, and any evidence that the emergency removal continues to be necessary, as well as steps taken to provide notice to the child's parents, custodians, or tribe. And tribe. An emergency removal of an Indian child cannot last more than 30 days without the following determinations. Restoring the child to the parent or the Indian custodian would subject him or her to imminent physical damage or harm. The court has been unable to transfer the proceeding to the jurisdiction of the appropriate tribe, or it has not been possible to initiate a child custody proceeding as defined under Section 23.2. Now, California law tells us, specifically Section 305.5F of the Welfare and Institutions Code, the emergency removal of an Indian child is not prohibited, but it's required to terminate once it's no longer necessary to prevent imminent physical damage or harm to the child. Section 361.31 of the Welfare and Institutions Code says the emergency removal of a child known to be or believed to be an Indian child shall be in the least restrictive setting where his or her needs may be met, and then the placement preferences should be followed. Now, this is a very popular topic, petitions to transfer a case from state to tribal court. And Regulation 23.115 tells us how to go about doing this. First of all, it tells us who can petition for the transfer of a proceeding. Subsection A says either parent, the Indian custodian, or the Indian child's tribe may request at any time, orally on the record or in writing, that the state court transfer a foster care or termination of parental rights proceeding to the jurisdiction of the child's tribe. The right to request a transfer is available at any stage in each foster care or termination of parental rights proceeding. What happens after a petition to transfer is made? Well, upon receipt of a transfer petition, the state court must ensure that the tribal court is promptly notified in writing of the transfer petition. This notification may request a timely response regarding whether the tribal court wishes to decline the transfer. And California doesn't have a provision on point. Now, if it's the tribe that is petitioning for transfer, well, obviously the tribe is probably aware of the transfer petition. But if it's a parent or an Indian custodian, you'll want to make sure that the tribe is aware of this. What are the criteria for ruling on a transfer petition? Well, the state court must, and must is underscored here, must transfer the child custody proceeding unless the court determines that transfer is not appropriate because one or more of the following criteria are met. If either parent objects to such a transfer, then the transfer will not go forward. If the tribal court declines the transfer will not go forward. And finally, if good cause exists, the state court may deny the transfer petition. We'll talk more about that in a moment. But you see under California law, the criteria is very similar. If the court finds that one or both parents object, if the tribe does not have a tribal court, or the tribal court declines the transfer petition will not go forward. Now, what is good cause to deny a transfer? Well, according to the regulations, if any party believes good cause to deny the transfer exists, the party must state that reason or reasons orally on the record or provide them in writing and to the other parties to the proceeding. Any party to the proceeding must have an opportunity to provide the court with their point of view regarding whether or not good cause exists to deny the transfer. The court cannot consider the following. This is very important. Whether or not the proceeding is at an advanced stage, if the Indian child's parent, custodian, or tribe did not receive notice of the proceeding until an advanced stage, whether there have been prior proceedings involving the child for which no petition to transfer was filed, whether transfer could affect the placement of the child, the Indian child's cultural connections with the tribe or its reservation, or the socioeconomic conditions or any negative perception of the tribal or BIA social services or judicial systems. None of these can be a basis for a good cause determination. And finally, the basis for any state court decision to deny the transfer should be stated orally on the record or in a written order. Now, under California law, a good cause determination may exist if the evidence necessary to decide the case cannot be present in the tribal court without undue hardship to the parties or witnesses, and the tribal court is unable to mitigate the hardship by making arrangements to receive and consider evidence or testimony by use of remote communication, hearing evidence at convenient locations, or by other means. If the proceeding was at an advanced stage when the petition to transfer was received and the petitioner did not file the petition within a reasonable time, if the Indian child is over the age of 12 and objects to the transfer, if the parents of a child over 5 are not available and the child has had little or no contact with the Indian child's tribe. The socioeconomic conditions and the perceived adequacy of social services or judicial systems may not be considered in a good cause determination. The burden of establishing good cause to deny the transfer shall be on the party opposing the transfer. If the court believes or any party asserts that good cause to the contrary exists, it shall be stated in writing and made available to all parties petitioning for the transfer. And the petitioner shall then have an opportunity to provide what's called rebuttal evidence. So that was Welfare and Institutions Code, Section 305.5c. The California Rule of Court 5.483 also addresses good cause and states that the court may not consider socioeconomic conditions and the perceived adequacy of tribal social services, tribal probation, or the tribal judicial systems in its determination. As far as evidentiary burdens, the burden of establishing good cause to deny a request to transfer is on the party opposing the transfer. And if the court believes or any party asserts that good cause exists, the reason for that belief must be stated in writing in advance of the hearing and made available to all parties who are requesting the transfer. And the petitioner must have an opportunity to, again, provide rebuttal evidence. Now we're getting to adjudication. So we've talked about pretrial requirements, and now we're going to talk about adjudication. So very often, this is where when a dependency case is at the jurisdiction stage. How does the state court ensure active efforts have been made? Well, BIA Regulation 23.120 tells us that before ordering an involuntary foster care placement or terminating parental rights, the court must conclude that active efforts have been made to prevent the breakup of the Indian family and that those efforts have been unsuccessful. Active efforts must be documented in detail in the record. Very important. California law tells us the determination as to whether reasonable efforts were made to prevent or eliminate the need for removal must be stated whether it was reasonable under the circumstances not to make any of those efforts, or in the case of an Indian child, whether active efforts were made and that those efforts have proved unsuccessful. The court shall state the facts on which the decision to remove the minor is based. So active efforts are important under any standard, but they are defined and described more thoroughly under the regulations than under California law. So continuing on, Welfare and Institutions Code 361.7 tells us that a party seeking an involuntary foster care placement or termination of parental rights shall provide evidence to the court that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family, and that these efforts have proven unsuccessful. What constitutes active efforts shall be assessed on a case-by-case basis. Now that's not so different than the new regulations, but remember, the new regulations give us examples. California law does not. Active efforts shall be made in a manner that takes into account the prevailing social and cultural values, conditions, and way of life of the Indian child's tribe. Active efforts shall utilize the available resources, resources of the Indian child's extended family, tribe, and tribal and other Indian social service agencies, and individual Indian caregiver service providers. No foster care placement or guardianship may be ordered in the proceeding in the absence of a determination supported by clear and convincing evidence, including testimony of a qualified expert witness, that the continued custody of the Indian child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. Clear and convincing evidence is a high evidentiary standard. It's by no means the highest, but it is very high. Now, the regulations tell us that the court must not order a foster care placement unless there is clear and convincing evidence present, including the testimony of one or more qualified expert witnesses demonstrating that the child's continued custody by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. The court must not order a termination of parental rights for an Indian child unless evidence beyond a reasonable doubt is presented, including the testimony of one or more qualified expert witnesses demonstrating that the child's continued custody by the child's parent or custodian is likely to result in serious emotional or physical damage to the child. This is a higher evidentiary standard, beyond a reasonable doubt. Subsection C of Section 23.121, for a foster care placement or termination of parental rights case, the evidence must show a causal relationship between the particular conditions in the home and the likelihood that continued custody of the child will result in serious emotional or physical damage to the child subject to the proceeding. Without causal relationship, if the evidence shows only the existence of community or family poverty, isolation, single parenthood, custodian, crowded or inadequate housing, substance abuse, or non-conforming social behavior. These things do not by themselves constitute clear and convincing evidence or evidence beyond a reasonable doubt. California law tells us that no foster care placement or guardianship may be ordered in the absence of a determination, supported by clear and convincing evidence and the testimony of a qualified expert witness, that the continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. Now, we get this question a lot. Who can be a qualified expert witness under the regulations? Well, a qualified expert witness, according to Regulation Section 23.122, must be qualified to testify regarding whether the child's continued custody by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child, and should be qualified to testify as to the prevailing social and cultural standards of the Indian child's tribe. A person may be designated by the Indian child's tribe as being qualified to testify to the prevailing social and cultural standards of the tribe. The court or any party requesting may request the assistance of the Indian child's tribe or the BIA serving the tribe in locating persons qualified to serve as expert witnesses. The social worker regularly assigned to the Indian child may not serve as a qualified expert witness in child custody proceedings. And I would point out, this refers to the county worker. Sometimes it is the tribal social worker who serves as the expert witness. California law is a little different, and actually California law gives us examples, which makes it a little more thorough and helpful than the regulations are on this point. When the testimony of a qualified expert witness is required, that expert witness can include, but is not limited to, a social worker, a sociologist, physician, psychologist, traditional tribal therapist and healer, tribal spiritual leader, tribal historian, tribal elder, provided that the individual is not an employee of the person or agency recommending foster care placement or termination of parental rights. In considering whether the involuntary placement, to involuntarily place an Indian child in foster care or terminate parental rights, the court shall require the qualified expert witness to testify regarding whether continued custody of the child is likely to result in serious emotional or physical damage. Consider evidence concerning the prevailing social and cultural standards of the Indian child's tribe, including that tribe's family organization and child rearing practices. Persons with the following characteristics, and this is again according to California Welfare and Institutions Code section 224.6, persons most likely to meet the requirements for the qualified expert witness are a member of the child's tribe who is recognized by the community as knowledgeable in tribal customs as they pertain to family organization and child rearing practices, an expert witness having substantial experience in the delivery of child and family services to Indians and extensive knowledge of prevailing social and cultural standards and child rearing practices, or a professional person having substantial education and experience in the area of his or her specialty. The court or any party may request the assistance of the Indian child's tribe or the Bureau of Indian Affairs in locating persons qualified to serve as expert witnesses. The court may accept a declaration or affidavit from a qualified expert witness in lieu of testimony, and that is in lieu of live testimony, but only if the parties have so stipulated in writing and the court is satisfied the stipulation is made knowingly, intelligently, and voluntarily. Now, voluntary proceedings. Remember, we talked about voluntary proceedings under the definition, and in terms of the application of the Indian Child Welfare Act. State courts must require participants to a voluntary proceeding to state on the record whether the child is an Indian child or whether there's reason to believe he or she is. If there is reason to believe the child is an Indian child, the state court must ensure the party seeking placement has taken all reasonable steps to verify the Indian child's status. This may include contacting the tribe to verify it. Where a requesting parent requests anonymity, a tribe receiving information must keep relevant information confidential. There's no analogous provision under California law. Obtaining parental consent. Remember, we're still talking about voluntary proceedings. Parental consent to foster care, pre-adoptive, or adoptive placement must be executed in writing and recorded before a court of competent jurisdiction. It must include the terms and consequences of consent, limitations on withdrawal of consent, certify the terms and consequences explained to the parent or Indian custodian on the record in English or his or her primary language. The consent does not need to be an open session of court when confidentiality is requested, but still must be before a court of competent jurisdiction. Consent given prior to or within 10 days after the birth of an Indian child is not valid. Now, under California law, consent must be in writing at least 10 days after the child's birth. The judge certifies the terms and consequences are explained and understood. The parent or the Indian custodian may withdraw consent at any time for any reason and then have the child returned. Family Code Section 8606.5, it's identical to the Welfare of Institutions Code, except that the consent must be withdrawn before the final adoption decree. Probate Code Section 1500.1, also identical, except that the consent must be withdrawn before the issuance of guardianship letters. So, what information is required in the consent? Well, the conditions, if any, and then the child's name and date of birth, the name of the child's tribe, the child's enrollment number, the parent's enrollment number, if known, the name and address and other identifying information of the consenting parent or Indian custodian, the name and address of the person or entity who arranged the placement, and the name and address of the prospective foster parents, if known. Now we're at disposition. Disposition is a very significant moment in the life of a dependency case. And this is when courts need to make a finding about placement preferences. Placement preferences are one of the most well-known parts of the Indian Child Welfare Act. The placement preferences in sections 23.130 and 23.131 apply to any pre-adoptive, adoptive, or foster care placements. When consenting parent requests anonymity in voluntary proceedings, the court must give weight to that request in applying the preferences. And the placement preferences must be applied in any foster care, pre-adoptive, or adoptive placement unless good cause exists under 23.132. So there are placement preferences. We'll talk about what they are in a moment. But there is also a good cause provision that allows a court to deviate from the placement preferences, much like finding good cause not to grant the request to transfer jurisdiction. We talked about that a little while ago. Under California law, in addition to the placement preferences, if the child's tribe adopts a different placement order, that placement order shall be followed, so long as it's the least restrictive setting and appropriate to the needs of the child. When of sufficient age, the placement preference of the child shall be considered, but again, there's no clarification on what sufficient age means. I imagine that's done on a case-by-case basis. So the placement preference for adoptive proceedings really fall in descending order as number one, a member of the Indian child's extended family, and again, extended family does not necessarily mean Native American family, other members of the Indian child's tribe, and other Indian families. If the child's tribe establishes by resolution a different placement preference list, then that placement preference list applies. The court must consider the placement preference of the Indian child or his or her parent. California law has only slightly different wording. Now, Regulation 23.131 talks about the placement preferences for foster care and pre-adoptive placements. And it notes that children must be placed in the least restrictive setting that at most approximates a family, taking into account sibling attachment, allowing the Indian child's special needs, if any, to be met, and is in reasonable proximity to the Indian child's home, extended family, or siblings. However, preference must be given in descending order to a member of the child's extended family, a foster home licensed, approved, or specified by the tribe, an Indian foster home licensed or approved by an authorized non-Indian licensing authority, and an institution for children approved by a tribe or operated by an Indian organization suitable to meet the child's needs. Again, if a tribe has a different preference order, that applies, and consider the child's preference. California law includes a virtually identical list, and we'll see that in a moment. Regulation 23.132 talks about good cause to deviate from the placement preferences. So any party asserting good cause exists to deviate from the placement preferences must state the reasons orally on the record or provide them in writing to the parties and the court. The party seeking to deviate from the placement preferences bears the burden of proving by clear and convincing evidence that good cause exists to deviate. A court's determination of good cause must be made on the record or in writing and should be based on one or more of the following considerations. Request of one or both parents if they attest they have reviewed the placement options. The request of the child if he or she is of sufficient age and capacity to understand the decision. The presence of sibling attachment that can only be maintained through a particular placement. The extraordinary physical, mental, or emotional needs of the child that would not be available in the community where a preferred placement lives, or the unavailability of a suitable placement after a diligent search was conducted and concluded none has been located. And this does happen. There are cases where there are no placement preferences available. Moving on, subsection D, a placement may not depart from the preferences based on socioeconomic status of any placement relative to another placement. And a placement may not depart from the preferences based solely on ordinary bonding or attachment that flowed from time spent in a non-preferred placement made in violation of the Indian Child Welfare Act. And this, I believe, directly addresses California law, specifically what has been called the existing Indian family exception. Now, participation by alternative methods. This is very important because a tribe's right to intervene as a party to a case means nothing if it is so complicated or difficult for them to do so that it's just about impossible. So the regulation 23.133 says, if it possesses the capability, the court should allow alternative methods of participation in state court child custody proceedings involving an Indian child, such as participation by phone, video conferencing, or other methods. Now, California law does not have an analogous provision, although it probably should, given the number of tribes that are in California or outside of California and involved in California dependency cases. Okay, many of these tribes have varying levels of resources. They cannot all be there in person, so why not have something written in the law to make it possible for them to participate, to really allow them to give their input and exercise their right as tribal governments. I have to say in Southern California, most state courts are reasonable and accommodating, whether they use court call or allow tribal attorneys and representatives to call in directly to the courtroom. But still, I'm glad that this regulation addresses participation by alternative methods. As I said, this is very important because tribes vary widely in their budgets and their resources and their staff sizes, and it's not always possible to appear in person. And budgets and distance sometimes make it difficult. But rest assured, no matter how a tribe participates in a proceeding, they do have an interest involving their youngest members. Now, access to records, this is another issue that comes up from time to time, especially when a tribe intervenes later on in a case. Sometimes they have to play catch-up, but agencies are not always forthcoming with information, and that makes it difficult for a tribe to know how to proceed. So Regulation 23.134 states that each party to an emergency proceeding or foster care or termination of parental rights proceeding under state law involving an Indian child has a right to examine all reports and other documents filed or lodged with the court upon which any decision with respect to such action may be based. Now, California Dependency Law, if you've looked at the that thick blue sizer book that comes out every year, Section 2.109, subsection 12, notes that counsel in dependency proceedings must be given access to all the records relevant to the case that are maintained by state and local public agencies. But there's no required timeline. However, documents should be produced within 30 days. And frankly, I just don't think that this language is as strong as what we see in the new regulation. So I think this is a great addition to what we already know about the Indian Child Welfare Act. Why is access important? Well, petitions detailing allegations, status reports containing progress, case plans, recommendations, these are all needed by tribes to help them make informed decisions. And if a tribe is the last party to enter a case, which it often is, late or unavailable records or case files put them at a disadvantage. Tribes don't want to have a separate hearing just to order an agency or another party to do something they should have done at the beginning. Now, vacating adoption based on consent obtained through fraud or duress. Now, this is also something that comes up from time to time. The BIA regulations, particularly 23.136, tell us that within 2 years of an adoption decree of an Indian child by a state court, the state may invalidate the voluntary adoption on finding the parent's consent was obtained by fraud or duress. Upon the parent's filing of a petition to invalidate the final decree of adoption of the parent's Indian child, the court must give notice to all parties to the adoption and the Indian child's tribe and must hold a hearing on the petition. Where the court finds that the parent's consent was obtained through fraud or duress, the court must vacate the final decree of adoption, order the consent revoked, and order that the child be returned to the parent. Now, California Family Code Section 8606.5, subsection C, allows the parent of an Indian child to withdraw consent if that consent was obtained through fraud or duress. He or she may petition the court to vacate the decree. Upon finding that consent was obtained through fraud or duress, the court shall vacate the decree and return the child, provided that no adoption has been effective for at least 2 years, may be invalidated unless otherwise permitted under state law. So different language, but actually very similar provisions. The 2 years requirement, consent obtained through fraud or duress. So here we see the regulations kind of mimicking California law. Note that Section 23.136 of the regulations requires that notice be given to all parties to the adoption proceedings and the Indian tribe, the child's Indian tribe, that is, and that's why I highlighted that phrase in red on the previous slide. That section further requires a hearing to be held on the petition, which is probably implied in the family code that I've quoted, but it's not stated specifically. Now, petitions to invalidate for ICWA violations. Now, a lot of parents allege or claim that the Indian Child Welfare Act has not been followed, or that it's been violated, and therefore the case should be invalidated entirely. Well, the regulations tell us that the following parties can petition to invalidate an action for foster care or termination of parental rights for ICWA violations: the Indian child, the parent or Indian custodian, or the Indian child's tribe. And the court must determine if it is appropriate to invalidate. There is no requirement that the person petitioning to invalidate had his or her rights violated. He or she may challenge the action based on any violation in the act, and that is significant for standing purposes. Okay, so the person claiming the violation need not have his or her own rights violated. They just need to claim that any part of the act was violated, specifically sections 1911, 1912, or 1913. Now, the California Family Code, section 175E, permits the same parties to petition to invalidate an Indian child custody proceeding for foster care, guardianship, or the termination of parental rights. So the regulations is not really giving us anything new, but it's still good language. Probate Code section 1459E contains language almost identical to the California Family Code, and the Welfare and Institutions Code contains the same language as the Probate Code section listed above. Now, Regulation section 23.138, an adoptee's right to tribal affiliation information. So when somebody is adopted under state law, that person's records are usually sealed, and that person may or may not be aware of his or her tribal affiliation. But Regulation 23.138 tells us that upon application by an Indian who has reached the age of 18 and who is the subject of an adoptive placement, the court that entered the final decree of adoption must inform such individual of the tribal affiliations, if any, of the Indian's biological parents, and provide such other information necessary to protect any rights, which may include tribal membership resulting from the individual's tribal relationship. Now, California Family Code section 9209A and Health and Safety Code section 102705 contain similar authority to access such information. And I can tell you that at California Indian Legal Services, we on a regular basis hear from people who had been adopted sometime in the past, and they are trying to unseal their birth records to learn about their tribal affiliation. Now, we did not get to severability or the effective date, but remember what I said at the beginning of the webinar. The effective date was December 12, 2016, and what we are looking for are subsequent proceedings. So a case need not be initiated or started after that date. It's just we're looking for a subsequent hearing that would trigger the application of these new regulations. So I hope you enjoyed this webinar. I hope you learned something. If you'd like more information about the new regulations, I suggest you go to www.indianaffairs.gov. That will take you to several links from the BIA to the Office of Indian Services and Human Services. Will link you up to information all about the Indian Child Welfare Act. You can also check out CILS's website, which is www.calindian.org, or contact me at mvazola@calindian.org, or my colleague Jasmine Andreas at calindian.org. Jasmine assisted in preparing this webinar, and she is the directing attorney of CILS's Bishop office. So I hope you enjoyed it. I hope it was helpful, and good luck. Thank you.